Hello. Welcome to Bear Paw Media and Education's Public Legal Education webinar series. My name is Nadine Callahoo Hansen. Bear Paw Media and Education is a Department of Native Counseling Services of Alberta, and our primary goals are to make public legal education understandable, accessible, and affordable for Indigenous people. We at Bear Paw are not lawyers, although we do endeavor to make sure that this information is correct and current to the best of our abilities and is edited by lawyers. This webinar contains legal information only. Laws change with elections and societal values. So this information is designed to be general in nature and may not apply to your specific situation. It may be necessary for you to consult a lawyer for legal advice to assist you. For more information, look at our website at bearpawlegalresources.ca or follow us on social media at Bear Paw Legal. Today's topic is going to be on the Residential Tenancy Act or the Landlord and Tenant Act in Alberta. I'd like to begin by acknowledging that the land in which we gather, or at least I gather, is Treaty 6 territory and a traditional meeting ground and home for many Indigenous people, including the Cree, Saulteaux, Blackfoot, Métis, and Nakota Sioux. So I'd like to begin by screen sharing. Okay. So perhaps you've just found a great new apartment, or you're starting to look around for a new place to live. Before making that big move, it's important for you to understand that you're about to enter into a legal agreement, a legal relationship with another party, the landlord. After you enter into your agreement, both you and the landlord will enjoy certain rights, and you will also have obligations to each other that need to be kept in mind. You will need to consider these rights and obligations at every stage of your relationship with your landlord. Before you move into your place, it's wise to have a basic understanding of the law that will affect you. The main purpose of the Residential Tenancy Act is to provide a minimum standard of conduct for both landlords and tenants. It is possible for you both to negotiate beyond the minimum standard, but most people find that the Act is a sufficient safeguard for both parties. Tenancy agreements or lease agreements or rental agreements arose by any other name. They're all the same. So whatever you call it should be in writing, but spoken agreements can be binding, but it could come down to your word against theirs. So to be safe, you should always have it in writing. I always recommend that when people enter into a rental agreement, that they should start a rental file. I don't care if it's a shoebox or an envelope or an actual file system, but start a file called rent and keep everything related to the rent in that file, shoebox, envelope, whatever it is. So your tenancy agreement, rental agreement, lease agreement, once it's signed and you receive a copy, put it in that rental file. You never know when you might need it. Once it's been signed, it becomes legal, and you're both landlord and tenant bound by it. It can be for a fixed term or a periodic tenancy. I'll get into that shortly. I'd also like to remind people that if you're moving into a premise, a property where the landlord actually lives, you're not renting, you're room and boarding, you're sharing facilities with the landlord. And the Residential Tenancy Act does not protect people who are in a room and board situation. There are some great free templates for room and board contracts available online. You just have to Google them or search whatever search engine you want to use to check that out. If you're in the Edmonton area, the Residential Tenancy Board on The corner of 66th Street and Fort Road would have copies of those for you. So with room and board, you want to make sure that you have a room and board agreement signed and dated by both you and the landlord. Include everything that is included in your room and board. So the total amount, as well as all of the services included in that room and board, because you don't want months to go by and then all of a sudden the landlord to come back at you and want you to share or to pay 50% of the utilities when there was a verbal agreement that that would be included in your room and board. If there isn't anything in writing, it becomes your word against theirs. So tenancy agree, or the Residential Tenancy Act does not protect people in room and board situations. You really need to have a written contract there. I often get questioned about, does subsidized housing, people living in subsidized housing, are they protected by the Alberta Residential Tenancy Act? And the short answer is absolutely yes. In fact, subsidized housing still must follow the Alberta Residential Tenancy Act with just a few exceptions. If tenants' income levels exceed the maximum of the subsidy program, then their tenancy can be terminated. If they fail to report or misreport their income, their tenancy can be terminated. If the subsidy program has been canceled, their tenancy can be terminated. Otherwise, they have to follow any other reasons described in the Residential Tenancy Act. The other exception to the rules around for subsidized housing is around security deposits. Security deposits cannot be more than the actual amount paid by a renter for 1 month. And so if a renter is in subsidized housing and their portion of the rent, say the rent is $1,000, but the renter only pays 400 and 600 of that is subsidized, the landlord can only demand a security deposit equal to the actual amount that the renter pays. So in this instance, the landlord cannot ask for more than $400 for the damage deposit or security deposit. And in fact, if the landlord tries to request more than that, then they're guilty of a criminal offense and they could actually be criminally charged and fined up to $5,000. So there are some very serious consequences to landlords not following the laws around residential tenancy. So before people sign a lease agreement, tenant agreement, rent agreement, whatever it is, they need to be fairly positive they know what their immediate future holds. So there's pros and cons to fixed and periodic tenancy. With a fixed tenancy or a fixed rental agreement, that would be for a longer term. It means that you're signing a contract for 6 months or a year or 2 years, longer term. Now, there are benefits to a longer term. It means that usually the landlord will give you a break on the rent. Maybe they will drop $100 a month off of the rental rate, or maybe they'll give you 1 month of free rent. Um, so there's always that extra benefit. Also, you have the confidence or the freedom of knowing that your rent and your rental conditions cannot be changed for the whole duration of that fixed term. However, you need to be sure that you can stay in that place for that whole time, because If for whatever reason you need to leave the term early, your landlord can sue you for the balance owing to the end of that term. So you want to make sure that if you're signing a fixed tenancy agreement, that you're going to be able to fulfill that full term, because the landlord doesn't necessarily have to release you early. Sometimes they do, but they don't have to. A periodic tenancy is week to week, month to month. So there is less um, need to stay put for a long term. However, there is less security in knowing that your rental conditions and rate will stay the same for a long term. The landlord then has the ability to change your rental conditions or rate at any time, as long as they comply with giving the person at least 3 months written notice before any changes in the conditions. So definitely some pros and cons between fixed and periodic tenancy. So you want to make sure you know what your future, your immediate future holds before you decide whether you're going to sign a fixed or periodic term lease agreement. Once the lease is signed, the landlord must give the renter a copy of that signed agreement. And in fact, the only time the renter is able, or the tenant is legally allowed to withhold rent, is if the landlord hasn't actually provided a copy of the signed lease agreement. The landlord has 21 days. And if after 21 days, the landlord still has not provided you with a copy of your agreement, you are more than able to withhold that rent. However, once the landlord does provide the tenant, the renter, with a copy of that agreement, the tenant is responsible for bringing the rent up to par, paid in full at that point. Otherwise, the renter is then in breach of their agreement. The landlord is responsible for making sure that the premise is available so that you can move in on the agreed date. So, for example, if the landlord contacts you the day before you're scheduled to move in, and they ask you to hold off moving in by 3 days because the painters haven't finished painting, or they're installing carpets or doing repairs or whatever the case may be. It's the landlord's responsibility to find the tenant, the renter, an alternate place to move into for the time being, or they are also responsible for any out-of-pocket expenses. Because after all, if someone's expecting to move into a place, then chances are they need to be out of somewhere by that date as well. And so maybe they need to extend the rent on a moving van or a storage unit for their stuff. Maybe they need to stay in a hotel for a few days, or they're living with family. But even during that time, if they've purchased groceries or ordered out for the duration, hang on to those receipts, because tenants can ask the landlords to reimburse them for the out-of-pocket expenses. Once that tenancy agreement, that rental agreement is signed, it's the landlord's responsibility to make sure that that property is ready to be moved in on that signed agreed date. The landlord must also make sure that the property is habitable for you to move into. And when I say habitable, I mean that they have a duty to make sure that the property does not present any risk to your life or your health. Pretty general. For instance, roofs, walls, and windows must be waterproof, windproof, and weatherproof. Plumbing should have no leaks or defects, and heating should be sufficient to allow all rooms to be at a minimum of 22 degrees Celsius. For those of us that are still in Fahrenheit, that comes to just under 70 degrees Celsius. So if you're living in an ice box and the landlord's doing nothing to make sure that it's fixed, then they are in breach of your contract. If you've got appliances that are on the fritz, you've got food spoiling because the fridge is not working properly, and the landlord continues to give you promises. Oh, I'll get that fixed. Oh, your stove, your oven's not working. I'll get that fixed. But then they don't actually follow through. Get them to put promises in writing. It is always in your best interest to make sure everything is in writing, signed by both of you if possible, and not just what are they going to do, but when, approximately when are they going to actually have the repairs done, so that you have something that you can put into your rent file. And if need be, you can always pull that out and use it as evidence in future should you need to. The landlord must give you a copy of the inspection report when you first move in. Now, if you are dealing with a landlord that says, oh, it's okay, we don't need an inspection report, for your own protection, do an inspection report. Again, Google search, whatever search engine you use, but search the internet. There are some great free inspection report templates that you can access. Again, you can also go to the courthouse, to the in Edmonton, actually in the larger centers, Edmonton, Calgary, Grand Prairie, Peace River, and I believe Lethbridge. There's the residential tenancy dispute resolution services, and they would have copies of inspection reports as well as lease agreements. So make sure that you go through it with a fine-tooth comb. Everybody has cell phones. It's impossible to get a cell phone without a camera in it. If there are any damages noted, take pictures of them. And what I always do is I email them to myself. And I've set up in my email a subdirectory or a file called rent. And any pictures or emails or text messages, anything that is digital that comes to me regarding my rent, I put it in my rent file, because also it is date stamped. So you can always pull that out if you need to and prove when the damage existed. Was it before you moved in or as you were moving in, whatever. So you will never know when you need to pull out that proof. So that includes things like stains on the counters, leaking plumbing, any damage to the walls, anything, absolutely anything, chips in the tile work, whatever. It is in your best interest to make sure that you take those photographs and stow them away, because seriously, if I had a nickel for every time I heard somebody complain that the landlord tried dinging all of their damage deposit when they moved out because of bogus repairs, I probably could retire rich. So it's just always in your best interest to make sure you cover your move in and your time spent there as best as possible. Again, the landlord cannot ask for more than 1 month's rent as a security deposit. If a landlord tries to pull a fast one on you and say that they want first and last month's rent as a security deposit, the most they can ask is equal to 1 month's rent. not to. So make sure that you assert yourself. You can simply say, I know that legally you can only ask for a maximum of 1 month's rent in for the damage deposit, and I'm prepared to pay that. The other thing about damage deposits is that it's still your money. Even when you give it to the landlord, it's still your money. And so the landlord has 2 business days to deposit that money into an interest bearing account. Because when you do move out, you're entitled to your full damage deposit back with interest. Of course, our interest rates are kind of in the tank right now, but still, if your money has earned a nickel or a dime, that's better in your pocket than theirs. So, 2 business days to deposit your money into an interest bearing account. While you're living there, the landlord is responsible for your peaceful enjoyment. So if you have a particularly nasty neighbor, it's not your responsibility to be always butting heads with the neighbor. If they're being unreasonable, um, you know, midnight, you've got young children that you're trying to get put to sleep, and they're partying very loud. Call the landlord. It's the landlord's responsibility to deal with those nasty neighbors. Always make sure that you're safe, of course. It's the landlord's responsibility to make sure that your place is always complying with public health standards. And so if you've got black mold creeping around the walls somewhere and you and your children are sick, it's the landlord's responsibility to make sure that that stuff gets fixed. That being said, bed bugs is a recurring problem. And so, as long as your landlord is actively trying to address the problem, they're calling in exterminators and they're doing everything under the sun to try and address the problem, then they're doing their due diligence and they are not in breach, unfortunately. So it's the landlord's responsibility to make sure that they are actively doing everything they can in their power to address public health issues. The landlord is absolutely not allowed to enter your unit without your consent or at least 24 hours written notice. If a child is the only one that's home, so someone under the age of 18 does not ever have the legal capacity to give consent. And so if the landlord shows up and your child's the only one home and they let them in, that is illegal. They have to get an adult's consent or provide 24 hours written notice. The only other time that they are able to enter your unit is if they believe that there is an emergency taking place. So they can smell smoke and there's smoke billowing from underneath the door. They've knocked several times and there's no answer. That's an emergency and they can enter. If they suspect that your unit is being flooded and there's water running into the unit below, whatever, again, no answer on the door, a state of an emergency and they can enter. They cannot change the locks without giving you a key to the new locks as soon as possible. Now, we see in the movies that landlords will change the locks if a renter owes a lot of back rent. They can't do that in Alberta. Only a judge has the power to lock people away from their stuff. So if the landlord changes the locks, no matter what the circumstances, they still have to provide a new key to that new lock to the renter as soon as possible. The landlord is responsible for major repairs. And I say major repairs because if if you need a light bulb replaced, that's kind of minor, and that's the renter's responsibility. But if your appliances are shorting out, if your plumbing is falling apart, leaking, whatever, then those are major repairs, and the landlord is responsible. The landlord is also responsible for all common areas, including maintaining and cleaning common laundry areas, maintaining the cleanliness of stairwells, elevators, and hallways. If you're lucky enough to live in a building with a gym or a pool, oh, don't I wish, then the landlord is also responsible for maintaining those areas. Also, if you live in a building where you collect your mail in the lobby, if you notice that some of the mailboxes, the locks are starting to loosen and anybody can open them with a fingernail or whatever, don't call Canada Post. It's not their responsibility. The maintenance of those mailboxes is the responsibility of the landlord. So, as well, mail areas in the lobby. Once you've signed that lease, the landlord cannot increase the rent for the duration of the lease. Many, many, many moons ago, you may have noticed a trend in Alberta where rent is on a quite a bit of a roller coaster, according to the gas and oil industry. And so when the gas and oil industry is booming, rent tends to skyrocket. And of course, during the economic downtrend, like the one we're in right now, rent tends to go down. And so uh, Albertans were trying to get the government to put a cap on rent so that landlords could not increase the rent to the point where they were putting families on the street. So rather than capping the rent, and I kind of understand, because if you owned a store and the government came in and said, you cannot charge more than 10 cents more than what you paid for that chocolate bar, you might be a little upset. And the same goes for property owners. They don't want the government stepping in and dictating how they can and can't do business. So instead, the government created this law that just does not make sense, but it's there, and I need to tell you about it. So in 2007, the government, the Alberta government, created a law that says that landlords cannot increase the rent more than once per year. It doesn't state a maximum or minimum of what they can increase it to, just it can't be more than once per year. They can't increase the rent more than once per year. How much is up to them? And of course, if you're in a lease agreement, they can't increase the rent anyway. If they choose to increase the rent or change any of your rental conditions, they still have to give you at least 3 months written notice, letting you know that they plan on making those changes. They always have to provide you with a way to contact them, their address, phone number, as well. If new landlords take over, the new landlords also have to make sure that you have their address and phone number, a way to contact them. And they have to comply or abide by all of the pre-existing rental agreements. Just because you have new landlords doesn't mean that they can step in and say, okay, everybody has to renegotiate their lease agreements. No, they still have to comply with the pre-existing ones. So what are the renters' obligations while they're living there? always abide by the agreement. And that's why I always say, make sure that you read your rental agreement before you sign it. Because even though rental agreements can be standard, landlords are able to add conditions uh, at will. Whatever they decide, they can do. I lived in a property where in my lease agreement it stated that if I was gone for more than 5 days in a row without uh, submitting in writing to the landlord that I was going to be gone, that after 5 days consecutive in a row, that they could determine that I had abandoned my property as well. I could not store anything, and I mean anything, other than patio furniture and a barbecue on my balcony. I could not dry clothes, and I couldn't store recyclables, nothing. And if I did, I was in breach of my lease agreement. So it's really important that people read their lease agreements because they could be doing something wrong and not even being aware of it. Make sure to pay rent on time when it's due. Now, landlords, this is a relationship, and landlords don't like preparing units for new renters every time they turn around. And so if a renter is facing a hardship, they would rather have the renter come to them and say, I need to get a week extension on my rent. Someone banged into my car and I have all these added expenses or whatever. But just make sure that you pay the rent when you say you're going to pay it, if at all possible, or when due. And usually, most rental agreements will actually include in the conditions any penalties for late rent anyway. So consult your lease agreement, rental agreement. Renters are responsible for not significantly damaging the premise. Of course, it's expected that there's going to be some normal wear and tear. We'll talk more about that during the exit stuff. But we are responsible for taking care of their property to the best of our abilities. It's our responsibility to not interfere with the rights of the landlord and other tenants. And so, talking about that nasty neighbor who likes to bang on the walls and party and whatever, they are actually in breach of their rental agreement because they also have a legal obligation to not interfere with the rights of the landlord and other tenants. It is our responsibility to keep the property reasonably clean. Life happens, right? And if you've worked lots of shifts in a row, you might not have done the dishes for a few days in a row. I mean, that's kind of reasonable. But if you've got bags and bags and bags of garbage piling up on the balcony or in the backyard, then that is not reasonable. It's our obligation, our legal obligation, not to do anything illegal in the premises and to not endanger the tenants, the other tenants, or their property. Now, sometimes if we need to get out of our contract early and the landlord is not willing to release us from it, we might want to consider subletting. And subletting is when we get somebody, probably our cousin or whoever. You got to be careful about those cousins too, right? So you might want to move somebody else in to take over your contract. However, if you're considering subletting, you have to get permission in writing from the landlord before you can sublease. As well, your subtenant, that's the person you're moving in, is not protected by the Residential Tenancy Act. And it's risky Because if the person you moved in doesn't pay a lick of rent for the whole time they're there and they destroy the property, who do you think the landlord's going to go after? And who do you think is going to legally be on the hook for all of the unpaid rent and damages? That's right, you. And so subletting is very risky. So you want to make sure that you know who you're subletting to very well. When you're planning on moving, you must give 30 days of written notice to landlords, and that's the norm, unless you're in a periodic tenancy agreement, week to week, month to month. Now, remember I said that with periodic tenancies, week to week, month to month, it's less obligations in terms of not having to stay there for long term, but does the renter have some sense of security that the landlord's not going to bounce them out just for no reason? No. Even under a periodic tenancy, the landlord still has to give the renter at least 3 months written notice to terminate their tenancy. So they do still have that 3-month buffer um, to prepare if they need to move. If someone has signed a fixed tenancy and they do need to leave early, they should give as much early written notice as possible. And again, if you are in a fairly positive relationship with the landlord, and it's a really good reason, and you've given lots of notice, the landlord may very well agree to release you early, but it is entirely up to their discretion. Tenants can expect their security deposits back with interest owing when they move out if there's no damage beyond normal wear and tear. And normal wear and tear is subjective. And so what you might think is normal wear and tear, the landlords might not consider it. And so it's kind of expected that after 3 years or so, that the unit is going to require painting, but you want to make sure that that you've left the place extremely clean and in good condition. Don't go out and spend a fortune on polyfill or anything else. I always suggest that if you always make sure you fill holes for nails, for pictures, and that kind of stuff. But go to the dollar store and pick up a cheap tube of white toothpaste, stick it on there, works just great. Sand it down a bit, works great, and you didn't have to spend a fortune on polyfill. Make sure that the walls are all washed and everything is neat and clean. If there are blinds, make sure those are cleaned. Check your lease agreement. I lived in, well, that place that I was living in my rental agreement, I wasn't allowed to clean my own carpets because the property owners had a contract with one standard carpet cleaning company that cleaned all the carpets. So it was in my contract that that would come off of my damage deposit. So I knew that going into it. Tenants are responsible for removing all of their belongings from the premise when moving out. And in fact, anything that is left behind, if the landlord deems, assesses that it is worth less than $2,000, they can do whatever they want with it. Toss it out, put it in another unit, whatever. If they do believe that the property is worth more than $2,000, they actually have to legally store it for 30 days. And anytime during that 30 days, if the owners come back for it, they can get their stuff back and would then have to pay for the cost of the storage unit. Uh, During that 30 days, the landlord also would have to apply to the courts for permission for an order to dispose of that property worth more than $2,000. And even then, even with a judge's order giving them permission to dispose of it, they would still have to keep records, a transaction record for 3 years, so that anytime up to 3 years after the tenant moved out, if the tenant came back and said, oh my gosh, I just remembered that I left my Picasso painting, it's a family heirloom and I left it behind. What happened to it? What did you do with it? As long as it was before 3 years, the landlord has to be able to go back into their records and be able to tell that tenant exactly what happened to their family heirloom Picasso painting. Getting into some eviction notices. The standard eviction notice in Alberta is 14 clear days. And when I say clear days, that means that the landlord can't actually count the day the notice was served and the moving day. So it actually works out to 16 days. On that 14-day notice, it must be in writing. It must give the address of the property. It must be signed by the landlord. It must give the amount of the rent that is due at the date the notice is given, if that's the reason why the eviction notice was issued. It must give the amount of rent that will be owed for the notice period. State the reason for the termination if it wasn't because of overdue rent, and state the date the tenancy will end. Just because somebody receives an eviction notice from the landlord does not mean they have to move. If the eviction notice was because of overdue rent, if the renter brings the rent up to date, it automatically voids the termination notice, the eviction notice. As well, no matter what the reason, if the tenant disagrees with it, they can actually submit in writing a notice of objection. And again, you can get a notice of objection form from the Edmonton Residential Tenancy, any of the courthouses, or you can just simply put in writing and include the address of the property, make sure that you, the tenant, sign it, and state the reason why you object to the eviction notice, and then submit that in person to the landlord. Once the landlord receives that notice of objection before the end of the 14-day eviction notice, they then have two choices. They can either just walk away and void the eviction notice, or they have to go to court. They would then have to apply for an eviction notice at court, because after all, only a judge has the true power to force you out of your home. All right. So technically, even the police are not supposed to assist with executing landlord issued eviction notices. The landlord must apply to the courts for a judge issued eviction notice in order for a tenant to actually be forced out. All right, so I did talk about this, the notice of objection. I just want to make sure that I've covered everything in it. Also, a tenant must give the objection notice to the landlord or their agent personally, or you can also choose to send it by registered or certified mail. However, it does need to be received before the end of that 14-day eviction notice. So serving personally is probably the safest bet. Recently, landlords had lobbied the government to make some changes to the laws to give them a little more power against particularly nasty tenants. And so Alberta, the province of Alberta, created something called a 24-hour eviction notice. And so landlords can now also choose to give a tenant a 24-hour notice to terminate tenancy, but only in extreme cases. And this would include if the tenant, the renter, had significantly damaged the rental property. If the tenant had physically assaulted the landlord or another tenant, or if they had threatened to physically assault the landlord or another tenant. So you're understanding that it is only to be used in extreme cases. The notice must be given to the tenant at least 24 hours before the date and time stated in the termination notice. The tenant cannot object to a 24-hour notice. However, that being said, if the tenant chooses not to leave by the date and time given in the notice, then the landlord must apply for a court date within 10 days to end the tenancy. If the landlord doesn't make that application within 10 days, the tenancy stays in place, so the renter stays there, and the renter can continue living in the property. So even though the tenant is not able to issue a notice of objection, if they chose to just not move, then the landlord would have 10 days to apply to the courts for a judge issued eviction order. And again, it would give the renter the opportunity to express themselves in court. So anybody that thinks that our laws are not created because of we the people, fleeing domestic violence. So in 2012, we had an MLA that was female MLA that was voted into office, and she had actually submitted a private member's bill because in her life experience, she had tried fleeing a domestically violent relationship and felt trapped in that relationship because her landlord wouldn't release her from her lease, and so wound up staying unnecessarily much longer in a domestically violent relationship than she felt was what was needed or necessary. And so she submitted this private member's bill, and it was passed in 2016, which gives people an easier opportunity to escape domestic abuse, being able to end their leases early without penalty. And so if somebody is escaping a domestically violent relationship, then what they need to do is, first and always foremost, get somewhere safe. That's always the primary concern. And then get supporting documents. If they've applied for an emergency protection order, QB protection, Court of Queen's Bench protection order, peace bond restraining order, or another relevant court order, or a certified professional statement declaring the tenant as a victim of domestic violence. So this might be a doctor, a nurse, a social worker, a psychologist, a psychiatrist, so anybody in the helping profession that might be able to sign off stating that they have been assisting this person and would be able to provide um, a signed document stating that they were a victim of domestic violence. So once somebody has their supporting documents, they're going to send contact information and document by email, fax, or in person. It's all there. And once you send your request in to the Safer Spaces at the Alberta government, a certificate will be issued within 7 days. A Safer Spaces advisor will contact the person directly to discuss the delivery option that works best for you. After all, you want to make sure that you are in a safe place. So the delivery option might be mailed or FedExed or whatever to a local women's shelter or to parents, family, whatever. Once you receive that certificate, you will serve it personally to the landlord along with a signed written notice to vacate in person or again by registered mail. In person's probably best, unless safety is an issue. Notice must be served at least 28 days before you move out, and within 90 days after the date in which the certificate was issued, the landlord will then terminate tenancy and without any financial penalties. So that means no matter what, your security deposit would be released to you, and the landlord could not sue you for any outstanding rent owed. So good deal, right? If for whatever reason you have a dispute or a disagreement with your landlord, again, I can't stress enough that this is a relationship. And so in any positive relationship, your first step should always be to talk to the landlord if there are disputes or disagreements. Write down details, take pictures for evidence if need be. Remember, make sure, put everything in your rent file, your rent shoebox, your rent envelope, whatever it might be. And if you're taking pictures, email them to yourself so that they're date stamped. If you aren't sure about your rights, you can call the Tenant Advisory Board. Most larger centers, Edmonton, Calgary, Grand Prairie, Peace River, Lethbridge, Red Deer, would have municipal tenant advisory boards. So check your local listings. If not, you can go through Service Alberta and ask to talk to the provincial residential tenancy board, and they would be able to answer your questions about what your rights are. As well, if you are in a major center, Edmonton, Grand Prairie, Fort McMurray, Calgary, we have at the local courthouse something called the Residential Tenancy Dispute Resolution Services. And as long as you financially qualify, you would then have access to court workers, staff lawyers, mediators, and also, not that I'm trying to drum up business for anybody, but as well, if there is a court worker program in your area, contact them because they often are able to assist people too. If at the last resort, you can also go through the court process. Now, there's a fairly significant application fee to file a court application. Please don't let this be the only thing that's stopping you. If you can't afford that application fee, you can always ask the court clerks for a fee waiver form, and it's a form that you can explain why you can't afford the application fee, and a judge will decide whether to reduce the fee or waive it altogether. It should not be the only thing stopping you from exercising your right to the courts. But then you also need to consider, is it worth suing? Consider the time and money that suing will cost you. A day away from work. Also, do you have enough evidence to support your claim? Well, if you started your rent file at the beginning of your rent and you put everything in that rent file, you should have enough evidence to support your claim. Also, you need to consider, if you win, will you be able to collect? Because even if you get a judgment, doesn't necessarily mean that you're going to be able to collect. You might actually have to take your judgment and file it with the Court of Queen's Bench to put a lien on someone's property or garnish wages or something. So consider who you're suing and what the likelihood is that you're going to get your judgment uh, money. However, if you have to sue, you can find the documents at the local courthouse or at albertacourts.ab.ca. Make sure you know who you're suing. When you pick up your forms, it will come with an instruction booklet as well. Make sure you serve all relevant persons and companies. And once you've served everybody, make sure you file affidavits of service with the court clerks. Now, this is a sworn document that you did in fact serve all those people that you said you'd served, and where, what locations were they at when you served them. If you're sued, you could try to negotiate the claim, pay the claim, which would void the dispute. You could file a dispute note, or you could consider mediation and pretrial conferences as well. If you suspect that you're being discriminated against, you can contact the Alberta Human Rights Commission, and there is only a 1-year deadline from the date of the event that you can file a grievance with the Human Rights Commission. If you think you've been denied housing because of discrimination, there is different phone numbers, whether you're in the northern or southern regions, or anywhere else. Service Alberta 310-0000. I love that one. I've also included a bunch of legal resources. The Edmonton Community Legal Center, they have a wonderful website. They have lots of resources as well. So you can check out our resources. Our web address is on the bottom of your screen, bearpawlegalresources.ca, as well as the Edmonton Community Legal Center, and go to their website. They also have some amazing resources, not just for residential tenancy, but lots of different stuff. On that note, I would like to end this session with just a really short but comical video.
All I really want to do is the things you just can't hide. Put your funk around it, babe, and I'll take you for a ride.
Welcome to our new home.
Awesome.
Have you ever had a problem renting a house or an apartment? Then this video's for you.
Before you move into a rental property, you and the landlord need to agree to the terms of your business relationship in a contract called a residential tenancy agreement, or lease.
So, would you like to do a written lease or a verbal lease?
Verbal. We're an oral culture.
So, would you like to do a written lease or a verbal lease?
I think our rights would be best protected if we had to lease in writing.
Your security deposit is $500.
Landlords will usually ask for a security deposit. The security deposit cannot be more than the equivalent of 1 month's rent. When you leave, if there's no damage to the rental, you are entitled to get your security deposit back.
What the?
We will need a receipt for that.
Legally, the landlord is required to give you a signed copy of the lease within 21 days. As a tenant, you're entitled to withhold rent until you've received a signed lease.
Holy, I can't believe I got this.
It is your obligation to follow the terms of the lease. If you break these rules, you could be evicted. You don't want to be evicted, do you? I don't want to be evicted. You don't want to be evicted, no, because you'll be in the alley, then they'll find you, then they'll cook you, they'll eat you.
Oh, hi, granddaughter. Oh, hi, nephew. Pituke. Oh, hi, my brother. Oh, my niece. What? Wow. Are you gonna come in?
If you allow someone who is not listed as a tenant or occupant on the lease to live at your rental, the landlord has the right to terminate tenancy and issue an eviction notice. However, if you have the landlord's consent, it doesn't matter if they are listed on the agreement or not.
This is your landlord.
Come in.
If the landlord is serving you a notice, the landlord must give the notice to an adult who appears to live with the tenant or post the notice in plain sight at the rental. If the landlord cannot serve in person, then the notice must be sent by registered or certified mail.
What's the catch? A Simina? That landlord.
If you object to the reasons stated in the 14-day notice, you must give your landlord a written notice of objection listing all the reasons why you disagree with the eviction. You must deliver this notice to the landlord in person or by registered or certified mail on or before the date listed to vacate. If you want more information on the Landlord and Tenancy Act, contact Service Alberta. Before signing a lease, make sure you know all your legal rights and obligations. Make sure you know your legal rights and obligations when making your way in the world. If you need help for any of the topics we've covered today, contact an NCSA court worker. But if you need legal advice, call a lawyer.
And so that concludes our webinar on Residential Tenancy Act in Alberta. Thanks for watching and have a wonderful day.